State of Vermont versus Shylo Bordeaux, docket 22-CR-7846. Ms. Bordeaux is here and appears to wish to represent herself in connection with this arraignment. The state is on the WebEx and is represented by Deputy State's Attorney Maria Byford. The matter was set over for today. Ms. Bordeaux was here yesterday and invoked the 24-hour rule in connection with the arraignment. Today we are here for the arraignment. The arraignment purposes is for you to decide which plea you wish to enter, Ms. Bordeaux, either a not guilty or a guilty or a no contest plea. Would you like for the court to read you the information and affidavit that the court has found probable cause for, which is a 2-count information alleging obstruction of justice and impeding a public officer?
No, I need you to go ahead and enter your name into the record as well as the prosecutor.
I entered the Deputy State's Attorney's name in. My name is Judge Lisa Warren. Do you wish for me to read you the information?
And the prosecutor to enter their name as well.
Please do not interrupt. Do you wish for the court to read the information and affidavit to you?
I actually just said that I need for the prosecutor to enter their name into the record as well.
The court is going to read the information and affidavit to Ms. Bordeaux. The charge in count 1 is obstruction of justice. The count reads as follows. Shylo Bordeaux in the County of Orleans at Newport on or about August 29th, 2022, correctly or by threats or force or by any threatening letter or communication, intimidated or impeded any witness, grand or petite juror or officer in or of any court or agency in a contested case of the state of Vermont, or cause bodily injury to such person or intentionally damage the property of such person on account of such person's attendance at, deliberation at, or performance of his or her official duties in connection with a matter already heard, presently being heard, or to be heard before any court or agency in a contested case of the state of Vermont, or correctly or by threats or force or by any threatening letter or communication, obstructed or impeded or endeavored to obstruct or impede the due administration of justice in violation of 13 VSA section 3015. The maximum penalty that the court could impose for a conviction of that offense is in prison not more than 5 years or fine not more than $5,000 or both. Count 2 is a charge known as impeding a public officer and reads as follows. Shylo Bordeaux in the County of Orleans at Newport on or about August 29th, 2022, hindered an executive, judicial, law enforcement, civil or military officer acting under the authority of the state or subdivision thereof, removed a weapon from the person of a law enforcement officer, deprived a law enforcement officer of the use of a weapon in violation of 13 VSA section 3001. The maximum penalty the court could impose for a conviction of that is in prison not more than 3 years or fine not more than $500 or both. The affidavit of Trooper Adam Ehrenberg reads as follows. On August 29th, 2022 at approximately 14:26 hours, Vermont State Police dispatch notified me of 2 juveniles in custody of Lamoille County deputies and Donna Peak, the grandmother. The juveniles, BB 102605 and LB 103010, had a juvenile pickup order signed by the Honorable Judge Thomas Devine on 6/10/22. The pickup order was attached to Orleans County Family Division case number 22JV820 for BB and LB to be in DCF custody. 2. I met with the Deputy Sheriff and Peak at the Eden General Store on Vermont Route 100 and followed Peak to the Orleans Courthouse located on Main Street in Newport. We arrived at the courthouse at approximately 15:32 hours. Upon arriving at the courthouse, I activated my WatchGuard V300 body-worn camera. 3. Peak came up to me and said, "The man with the gun is the boyfriend and that woman is the mother." I could see a shirtless male wearing plaid cargo shorts with a revolver strapped to his hip. The female was wearing a pink dress with brown braided hair. As Peak was telling me about the individuals, the 2 juveniles rushed towards a pewter-colored GMC Yukon with furniture strapped to the top and got into the back seat as the male with a revolver strapped to his hip said, quote, "Get on in here," end quote. I said, quote, "Hold up, I have a court order, do not get in here," end quote. The male proceeded to start slamming the doors closed, and the female said, quote, "You can stay away from this car," end quote. At this time, I grabbed the male's hands to prevent him from reaching for his revolver as he became very agitated and was yelling at me. 4. As this was happening, the female rushed around to the driver's side and got into the driver's seat to take off. At this time, a concerned citizen stopped and attempted to prevent the woman from driving off. Due to the male with the revolver posing a safety concern for the public and the juveniles, I was unable to stop the female from driving off. 5. The male was later identified as Dylan Zhang, 62787, by Peek. Peek also identified the female as the mother of the juveniles, BB and LB, Shylo Bordeaux, 71187. Zhang's was later identified through dispatch with a check of his criminal records. Bordeaux was identified by Sergeant Jensen and Sergeant Lint from their previous encounters with her. 6. Following this, Trooper Lindor, Trooper Alford, and Sergeant Lynch went to 242 Tanaki Road in Lowell, where Bordeaux is living, and were unable to find her or the juveniles. Also, law enforcement agencies in Grafton County, New Hampshire were notified and asked to check the address of 272 Turnpike Road in Grafton, New Hampshire. New Hampshire was unable to locate them as well. A Be on the Lookout was aired over St. Johnsbury and Royalton channels. Dispatch contacted Verizon and requested the cell phone 802-299-9489, which belongs to Bordeaux. Verizon said the last location was in Jay, Vermont at approximately 8:42 hours and was classified as an invalid ping. 7. Due to the inability to locate Bordeaux, I'm requesting the Honorable Court issue a warrant for her arrest. Based on the facts and circumstances, I have probable cause to believe that Shylo Bordeaux has committed custodial interference, a violation of 13 VSA 2451 when she took a child from the child's lawful custodian, the state of Vermont, knowingly without a legal right to do so when the person is a relative of the child and the child is less than 18 years old. Obstruction of justice, a violation of 13 VSA section 3015 when she impeded an officer in or of any court or agency in a contested case of the state of Vermont. Impeding public officers, a violation of 13 VSA section 3001 when she hindered a law enforcement officer acting under the authority of this state or any subdivision thereof. The court found probable cause for obstruction of justice and impeding public officers. Ms. Bordeaux, you must be aware of the following. The court has found probable cause for those 2 charges. You have the right not to make any statements beyond what you've already said in this case today or at any point in time. I've read you the maximum penalties that the court could impose if you were found guilty of either of those charges. You also have the right to request public defender at public state expense if you wish to do so, or you may hire an attorney, or you may represent yourself. If you wish to apply for a public defender, we'll have you fill out a public defender application. If you wish to hire a private attorney, we'll come back in a few weeks so you can tell us who that is, and he or she, in the meantime, can enter an appearance with the court if he or she will be representing you. Alternatively, when we come back, if you wish to represent yourself, we'll go over that procedure. You are not required to make any statement or answer any questions today or at any subsequent hearing, because any statement you do make could be used against you in this proceeding. You may seek to obtain pretrial release, which are conditions of release and bail that we'll address in just a moment. And I can't give you an estimate at this time as to where this case will flow in the system, but these are felonies, which mean they're more serious crimes. So as to when the next time we'll come back will be for an attorney or a peer hearing to determine whether or not you wish to represent yourself or not. As to what happens from here on out, that will be left to either your attorney or you and the state as to when you'll be ready to do any depositions in the case, file any motions in the case, be trial ready for the case to come back in for a trial either by jury or by court. Pursuant to the notice of potential collateral consequences, I do want to let you know of the following. If you are convicted of either of these offenses in the future, you should be aware that there are collateral consequences outside of what a court can impose for a possible sentence or penalty, and they are collateral consequences, meaning the court has no control over them. So some instances of collateral consequences, for instance, are that with So those are the Rule 5 rights that I want to let you know about, and I am required to let you know about. At this time, do you decline to have a public defender represent you for today?
So I'd like to enter into the record that the prosecutor are they refusing to enter their name into the record? I said that needed to happen earlier and it did not occur. So I take it they're refusing to enter their name into the record. And before we can proceed here today at all, I have a question, a concern that needs to be addressed.
So let me back you up.
I'm speaking and I listened to you and I did not interrupt you, and so I expect the same back.
Ma'am, first of all, I announced Ms. Byford. She is the Deputy State's Attorney, so she does not need to announce herself. She is
okay, and that's fine. Instead of just entering that in the record that she doesn't need to. Also entering into the record that I just requested that I be heard. I'm giving you the same respect. I just listened to everything that you said. And I'm telling you that I have a question before we can proceed here.
Let me just ask you this first. Do you want an attorney? That's an important question.
Well, what I want is my question answered and my concern addressed before we can proceed. So I require that you have a documentation of authorization to have clear title to that bench. I need you to provide that.
That's not what this arraignment is about. The arraignment is for you to be read the charges if that is part of the necessity of this hearing, which I've just done because you didn't answer my questions.
So are you refusing?
Hold on. And so that's the one requirement, is to apprise you of the charges that you're facing. They're just charges at this point. They're not proven. They're just charges or allegations. The second thing that we need to cover today is whether or not you want an attorney to represent you. I take it by your actions today and by the fact that there's no public defender here that you are declining that, which is fine. That is your right. We're going to set this for an attorney or a peer hearing, though, in a few weeks down the road. I'll give you that date in a moment. And the third thing is that we need to discuss after the arraignment piece, when you either enter a not guilty or a guilty or a no contest plea, is what conditions of release and or bail is appropriate here. So, do you wish to enter a not guilty plea to the charges that I read to you?
Well, I think that I already explained to you that I'm going to require your documentation of authorization as required by law for you to have before you can execute any duties on that bench. Before we can proceed, you need to provide me with that documentation.
I'm going to enter a pro forma not guilty plea for...
Objections? I object to that.
You may object. I'm entering a pro forma
And I'm going to go ahead and put you on notice of the U.S. Federal Codes, Title 18, Section 241 and 242. Anything that occurs from here on out, I am merely a witness, and I don't waive any of my rights.
Okay. Ms. Byford, what conditions and or bail is the state seeking here?
Your Honor, the state is seeking conditions 1 and 2. Condition 14, to have no contact with LB and BB, which includes in person, in writing, by telephone, email, or third person. Date of birth for BB, 10/26/05. For LB, 10/30/2010. Also, no contact with Dylan Jengs. We're asking for a condition 19, to obey any family court orders, and the state notes that the defendant was just served with a pickup order in dockets 22 JV 00821 and 21 JV 00821 for juveniles LB and ZB, and we ask that she comply with that court order as well, and I'll also direct the court's attention to an emergency care order which was issued in this matter. We're also asking for $20,000 cash or surety. Miss Bordeaux has been aware of an arrest warrant for her for over a week. She even participated in the WebEx hearing of her partner, Mr. Zhang's. She's called both Vermont State Police and the state's attorney's office, trying to discuss the matter, and yet she's never appeared herself or produced the children until she, even up to this point. So we believe that she is a flight risk. At this point, no one is aware of where the children are. And if the court would like to discuss that matter further, perhaps we need to seal the courtroom and discuss it in private.
I'm going to object and demand to be let to go on my own recognizances. I am not a flight risk. You guys gave me a court date. I came. I am back here again today, and I'm not going anywhere. And I am fully prepared to take any type of civil actions here.
Do you, I don't know, did you want to be heard on the conditions of release that the state is proposing? I understand you oppose bail. Do you understand what the conditions of release are that are being requested?
One thing that I'm very aware of is that you are required by law to have proper documentation of authorization to that title right there before you execute any of your duties. Are you refusing here on the record to provide me with that documentation?
That is not the purpose of an arraignment. The purpose of an arraignment is, as I said before.
Well, how can we proceed with an arraignment without this document? This is a very legitimate legal concern, and I have a case here, Horses versus Powers, okay, that says, and I can read into the record right now. I can go ahead and read into the record. So you're refusing for me to read into the record this case here. I brought up a legitimate concern. There are past issues with this state and with these proper documentations. The Vermont State Constitution, Chapter 2, Section 56 requires you to have this. The U.S. Federal Codes, Title 4, Section 101 requires you to have this. This is in accordance with law. Are you telling me that you are not required to follow these laws?
What I am saying is that is not the purpose for an arraignment. So the court, in accordance with the requested conditions of release, is going to grant in part some of the requested conditions. Conditions 1 and 2, 1 is to come to court when you are told to. 2 is to give your attorney and the court clerk your address and phone number. If they change, you must tell them immediately. I'm not going to impose a condition 14, no contact with the children, because I do not know what, if any, other orders out there state with regard to contact. However, I am going to impose a condition 19 to abide by and obey any family court orders. And the court is going to keep bail in place. Currently, I believe there was bail of $25,000. The state's asking for 20. The court is going to keep $20,000 bail in place, so there may be some credit to Ms. Bordeaux because of the bail that has been posted, which I believe it has been because she came yesterday and returned today. But the court does believe that there is some risk of flight. As the state pointed out back in June, there was action in another matter that was put Ms. Bordeaux on notice. She failed to bring or surrender the children over and has been at large with them. The state still does not know where the children are. So the court does believe Ms. Bordeaux is some flight risk here, despite a lack of Vermont record. I don't know if she has any out-of-state record. There is no in-state record. But the court does find that there is some flight risk here based on the actions alleged by the state and as alleged in the affidavit of probable cause filed by Trooper Ehrenberg. That is when Trooper Ehrenberg announced, hold up, I have a court order, do not get in there. Ms. Bordeaux allegedly got in the vehicle with the 2 children and fled. So the court does find that she is a flight risk. We will reduce the bail to $20,000 cash as surety, conditions 1, 2, and 19. I'm not going to impose a condition not to have contact with Dylan Jangs. I realize they may be co-defendants, but I'm not going to impose that condition. Those will be the conditions of the court and the bail that the court is imposing. And we will have you come back for an attorney or a peer hearing on October 11th at 8:30 a.m. If you hire an attorney before that time and he or she enters an appearance indicating that he or she will be representing you, he or she will file a notice of appearance here with the court, and you will not need to appear if that's filed before October 11th. If that's not filed before then and you don't want to hire or you can't hire for some reason a private attorney, you do need to appear here that day, and you can let us know either if you wish to be considered at that time for the public defender, and we'll have you fill out a public defender application, or we will engage in a discussion about whether or not you wish to represent yourself. So that will be the order of the court. We'll have you come back October 11th at 8:30 a.m.
Your Honor, to clarify, I'm sorry, Your Honor.
Yes.
To clarify, the state was requesting as a condition 19 that as a condition of release, the defendant be ordered to produce the children that are a subject of a family court
Objection.
order.
You already said, you already let conditions go. Objection.
Ms. Byford, I'm not ordering that. If there is an order in effect that Ms. Bordeaux is allegedly not complying with, and she is aware of it and has been served with it, that is for the court to determine on another date and at another time. I'm not ordering that today, but those will be the conditions and the amount of bail I'm ordering. That will conclude the arraignment.